Thank you, Mr. Chairman, Ranking Member. Acting Attorney General Blanche, thank you for your service and for appearing here. And thank you to your family and to the men and women of the Department of Justice who work tirelessly to fight crime and to make our nation secure. I'm grateful for their service. I'm sorry that your schedule apparently didn't permit us to meet before this confirmation hearing, but I hope and expect we'll find time to meet soon after today.
Absolutely.
Thank you. As I consider your nomination, like all other nominations to similar cabinet positions, I need to know you're qualified to serve. You demonstrably are. That you have the policy views to serve well. We will discuss that today. And most importantly, in this role, that you have the independence to serve as the Attorney General for the American people. And that last question has troubled me the most. You're in charge of a Department of Justice I don't recognize, prosecuting the president's political enemies, firing rank-and-file prosecutors and FBI agents because of the cases they were assigned to, slashing grants for law enforcement and public safety. These are some actions that in your previous confirmation hearing before us, you said you would not take. Now, I appreciate your statement walking back the $1.8 billion weaponization fund that you created, but I question how it got that far, and we'll get into that. You sat in appropriations hearing earlier this year before me and defended it at that time. In fact, if I remember correctly, you told me I was wrong for criticizing it. But following questions by Senators Durbin and Cornyn, I'm concerned it's not dead yet, and I think we should talk that through. Overall, this is not what I believe the American people expect or deserve from the Department of Justice. Having spent critical parts of January 6th in this room taking shelter from the mob, I just wanted to open with some questions. How many people were convicted of assaulting law enforcement officers on January 6th?
I believe around 120 approximately, but I could be off a few more.
You are. The answer is more than 200. And how many of those individuals had their sentences commuted or were pardoned by President Trump?
President Trump either commuted or pardoned every defendant from the January 6 events.
That's correct. And in this room right now and outside this room are Capitol Police officers protecting us in this hearing room. How many of them do you think might have friends or colleagues who were attacked by supporters of the president on January 6th?
I don't know the numbers, but I'm sure many of the Capitol Police officers who are here today were working on January 6th or knew people who were.
I'll just say that I consider it a shameful slap in the face of the men and women of law enforcement for those convicted of assaulting police officers to have been pardoned. I know you were not serving as Deputy Attorney General when President Trump pardoned those folks, but you said just a few moments ago that you were not celebrating this decision by the president. He was exercising his constitutional power. But earlier this year in front of CPAC, a conservative event, I would say from the transcript, you actually trumpeted it as an achievement. And I quote, saying, if you look at what happened to the men and women convicted because of January 6th, by 5 p.m. on January 20th, every one of them was either pardoned or had their sentence commuted by President Trump. So when folks say you've done nothing, I say you have a very short memory. Would you say that you're proud of President Trump's decision to pardon individuals who assaulted law enforcement?
No, that's not what I was saying there at all, Senator. So I was responding to inquiries around why more hadn't been done by the Department of Justice with respect to January 6 defendants. And so my answer was that January 6 defendants and some of their lawyers had a short memory because a lot had already been done. Indeed, by the end of the day on January 20th, they had all been pardoned or commuted. So I wasn't celebrating it. I was merely stating a fact, which is that the January 6 defendants did receive a very generous pardon or commutation from President Trump, every one of them on January 20th.
A generous, and in my view, for those who had assaulted police officers, unwarranted, unjustified, ahistorical, and a terrible precedent. Let me move on to questions I've asked in previous hearings. Is President Trump, just as a simple matter of constitutional law, eligible to run for another term as president in 2028?
I don't believe he is, no.
That is a correct, in my view, reading of the plain language of the 22nd Amendment. Why do you think several of the judicial nominees of this administration have refused repeatedly to answer that question simply and clearly as you just did when I put it to them?
I have no idea why they answer questions the way
Me neither.
I mean, you're asking me to speculate about something I don't know.
Is the Department of Justice that you're running independent from the White House?
the Department of Justice, like every single department in the executive, is part of the executive. I mean, Article 2 of the Constitution gives the power of the executive to President Trump. So we certainly operate with integrity. We certainly operate in the single mindset to serve the American people and do the right thing. But I am a member, if confirmed. I will be a member of the cabinet. I'm serving in the acting capacity that way now, just like the other cabinet members. And President Trump can fire me whenever he wants. So,
do you have a sense why he fired your predecessor?
I have no idea. I mean, President Trump, we all serve at the pleasure of President Trump in this administration.
Did President Trump ever post on Truth Social directing your predecessor to get at it, to prosecute his perceived political enemies?
I don't think those were his exact words. But
those were not his exact words,
no,
but clearly that was the intention. It is my impression, sir, that you are here rather than your predecessor because the president was unhappy with her failures to actually secure convictions of folks like Attorney General Tish James or former FBI Director Jim Comey. If you're confirmed and you're asked to take an action you believe to be illegal or unethical, would you resign?
That will never happen, but yes, if it were to happen, I'm not going to violate my oath to the Constitution.
I appreciate that answer. You did answer a question by a colleague about input that you gave to the president. Did you ever say no to the president on the slush fund, the anti-weaponization fund? Did you advise him against this?
I will not talk about communications I have with the president. I served as his lawyer for a couple years before he was elected. I'm the Deputy Attorney General and the Acting Attorney General, so I'm not going to talk about communications that I have with him. But Senator, I will say that President Trump trusts me to give him counsel. Counsel does not mean yes, man, and so that's true in my case, like it should be in any Attorney General's case.
Let me just for a minute bear down on the anti-weaponization fund. You've testified to the House. We are not moving forward with that fund, period. But you've repeatedly refused to put that commitment in writing or to submit a declaration to the court. You're an officer of the court, a member of the bar. You should be able to make that assertion in a court filing or even in a letter submitted to this body. On May 19th, you testified before the Justice Appropriations Subcommittee. Since the case had been dismissed, there was no judge and no mechanism for judicial review. But in an opinion this week, a federal judge wrote, and I'm quoting, that your testimony was at best misleading and at worst disingenuous, explaining the court remained available to review this agreement had you sought relief. Why not seek review of the settlement agreement or submit some record, some writing, given that the president continues to publicly champion this weaponization fund, and given your previous answer to me in another hearing that you wouldn't say whether or not those who assaulted cops on January 6th would be eligible for multi-million-dollar payouts? So
there's a lot of questions there. First
Indeed.
of all, we have put it in writing. It's in repeated court filings in EDVA and DC. So this narrative that you won't put it in writing happens not to be true. The reason why neither myself nor Secretary Bessent agreed to put a declaration in is because there's long-standing precedent that judges cannot ask cabinet secretaries or people like me to put in declarations. It has nothing to do with whether the fund is alive. I'm under oath today, and I've said it's dead repeatedly. I said it to the House Oversight Committee, and I'm happy to say it as many times as necessary. As far as what the judge said in Florida, just the last question you asked about Florida, that judge disagreed with what I said. I still believe the 11th Circuit precedent, which I've studied, I am right. So we'll see.
You did say earlier, this is the most transparent Department of Justice in American history. We have nothing to hide, and you started by saying we're here to rebuild trust. Two decisions or two OLC opinions I'm very interested in. I'm the senior Democrat on Defense and Intelligence Approach. I'm the most senior member of the Foreign Relations Committee on my side, who's currently serving on this committee. I'm curious as to why the most transparent department has refused to release the OLC opinion that justifies the 66 strikes the military has conducted on boats in the Caribbean, which have killed more than 220 people, either a redacted version or in a classified setting to me and others who are in relevant decision-making positions.
Well, Senator, we made the head of OLC available on multiple occasions to explain that to you and other members of the committee. And that is extraordinarily transparent and unprecedented that we've done that. Whether an OLC opinion is released, there's a lot of process that goes into that. But the idea that we were not transparent about our legal basis there is absolutely not true.
Okay. Another chance to be transparent. The FISA court in March certified your Section 702 proceedings, but found compliance deficiencies. This is an important power of the federal government that will soon be up again for a vote, and you have not declassified that opinion. Senators Cotton and Warner, Republican and Democrat leads on intelligence, in April wrote the administration saying that they expected declassification of this March opinion within 2 weeks, yet it remains classified. You have a bipartisan request from the leadership of Intel. Will you declassify it or make it available to us?
We'll continue to look at that. I agree with you that that's a very important issue, and we need 702 reauthorized.
Thank you. Last question, if I could. The Safer Supervision Act is co-sponsored by Senators Lee, Cornyn, Tillis, and Langford, and it gives a path forward to making sure that federal probation and parole is more effective. We've discussed it before. Will you meet with me to talk about ways that this important criminal justice reform, supported by federal law enforcement, could move forward?
I think that
Please give a short answer to that.
I think it's yes. Absolutely. I very much agree with what you're trying to do there, Senator.
Thank you.
Support journalism you trust. Support PBS News. Donate now, or even better, start a monthly contribution today.